Hey folks, Bill O'Leary coming to you today. And the question I'm going to answer for you is how to contest a will. And so what you're going to learn in this video is who can contest a will, what's the procedure for making a will contest, and what are the most common grounds for contesting a will. Real quick, my name is Bill O'Leary. As I said, my firm is Legacy Planning Law Group. I'm an attorney, and we focus on estate planning, probate and trust administration, and elder law. So here's the question to ask. If you have a will, does it have to be carried out exactly as it's written? Well, not necessarily. It can be challenged. However, not everyone can contest a will. Only those with proper what's called legal standing can do so, what are known as interested parties. And this is someone with a potential stake in the outcome of the estate. The most common types of interested parties are a beneficiary named in the will, obviously, maybe a beneficiary that was named in a previous version of the will, but not in the current will that's being offered for probate, and a potential heir. A potential heir is someone who, while they may not be listed as a beneficiary in the will, is a person who would inherit part of the estate if there was no will at all, what's called dying intestate. Now, first, let me be clear. Contesting a will, it's not common. It's a legal case, you see, that's usually very expensive and time consuming. And the law only permits a will contest based on specific legal grounds. The fact that you might be disappointed because you were hoping to get more under the will or a bigger share of the estate is not enough from a legal standpoint to contest a will. So if someone wants to contest a will, what's the first step in Florida? They have to file a petition in the probate court where the will is being probated and ask the court to revoke the will or hold it invalid. The petition has to be filed before the probate process is finished. And once probate starts, you only have a certain amount of time to contest a will. This is what's called a statute of limitations. Now, there are many reasons why someone might contest a will. Ironically, they are not all sort of derived from family fighting. So let me just focus on three of the biggest reasons that we see will challenges based on. Number one, lack of what's called testamentary capacity. This is a legal ground for contesting a will where it is saying that the deceased person did not have the mental ability to understand what was going on around them when they executed the will. For a will to be valid, the person making the will has to be able to make important decisions and sort of understand what they mean. Makes sense. So for example, they need to understand their assets, who their beneficiaries are, and the effect that the will is going to have. Someone with dementia really doesn't have the requisite legal capacity. Having a brain injury is another reason. Or you might have someone that might be intoxicated or on pain medications at the time of executing the will and might lack that capacity. Interesting. The Florida Supreme Court some decades ago held that even a lunatic may make a will in a lucid interval. So Florida courts have held that things like old age and maybe physical failings, memory lapses, or shifting judgment do not in and of themselves, you see, establish lack of testamentary capacity. Testamentary capacity is presumed to exist, which means that the burden of proving a lack of capacity is on the person challenging the will. And boy, it's an uphill climb. It really is. To make matters more difficult, it must be demonstrated that the person that's making the will lacked capacity at the time that the will was signed. And while they may have thought, on a Monday and a Wednesday of a given week that, aliens from outer space landed in their front yard, if they execute their will on a Tuesday, and they knew that aliens were not on their yard, and at 10 o'clock in the morning on a Tuesday when they signed the will, then they would have the requisite capacity. The person challenging the will, based on a lack of capacity, has a very heavy burden. Another ground for challenging a will is what's called undue influence. And here, the person making the challenge has to show that the person making the will was pressured or manipulated to write a will by someone who had power over them, like let's say a caretaker or a family member. A will must be written without undue influence to be valid. undue influence, in fact, is the most common ground for trying to invalidate a will. And in order to successfully challenge a will based on undue influence, several factors must be present, like the person exerting the influence has to get a substantial benefit under the will. They have to be in what's called a confidential relationship with the deceased, and they have to take steps to actively, I should say, procure the execution of the will. The legal ground of undue influence is more than just asserting that the deceased was persuaded by the beneficiary to change his or her will in the beneficiary's favor. The person challenging the will has to show that the deceased person's mind was so controlled by the undue influencer that they, in essence, had no free will. So you can almost say in another way that it has to be shown that the deceased person was overpowered mentally and emotionally by this undue influencer. And then a third ground, real quick, is what's called failure to follow legal formalities. Since wills are formal legal documents, they have to comply with certain requirements called legal formalities to be valid. And to be legally valid here in Florida, a will must be properly executed and witnessed. This means that the will has to be signed at the end in the presence of two witnesses. And the purpose for having the witnesses is so they can always later verify, the witnesses verify to the court that the will is authentic. And if the will fails to comply with any of these requirements, it can be challenged in a will context. So if you'd like to know more about how to contest a will, we would love to talk to you. So we would invite you to book a free 15-minute phone call called our discovery phone call. Just go to the bottom of this video. There is a scheduling link, or go to our website, legacyplanninglawgroup.com. Click on the blue button that says book your free call. Both ways, we'll take you to our booking calendar. Just pick a day and time that works for you, and we'll jump on the call at the appointed time. So Bill O'Leary signing off for now, and go make it a great day in a better world.